Mr. White, are you ready with Mr. Holland? You'll go ahead and have a seat. Mr. Abraham, if you can unmute.
I'm ready to.
All right, this is cause number CR 20-291, State of Texas versus Kyle James Holland. We're here on the state's motion to revoke Mr. White's. My understanding you just recently been retained.
Yes, sir, I have.
And would you like me to reset this to the next evidentiary docket, which will be January 22nd?
Yes, sir, that'll be fine.
All right, any objections from the state?
No, Your Honor, thank you.
All right, court recess Mr. Holland's case to January 22nd at 1:30. And Mr. White, if y'all reach some kind of resolution before then and want an earlier setting, I have them available. Just let me know.
Yes, sir, thank you.
Mr. Abraham, do we have anyone else that's ready?
Mr. Manning can do his resets.
Okay.
One of them. Well, one of them.
That's all right. Well, let's don't stop for just one. All right, court will stand in recess till the attorneys are ready.
Okay.
That would happen. Judge gets up here.
Your Honor.
Yes, ma'am.
Okay, Mr. Manning is ready.
All right, it'll be just a moment. All right, Mr. Manning, are you ready? Ms. Tabor, can you adjust that camera so I can see Mr. Manning? All right, who are you ready on?
Judge, this is Ms. Gregson.
This is cause number CR 23-182, State of Texas versus Amber Elizabeth Gregson on the state's motion to revoke. Go ahead, Mr. Manning.
Judge, we've reached an agreement, and unfortunately, we weren't able to get the paperwork done today. So we request her to be reset to do a plea at the next court setting.
All right, next court setting will be for you Thursday, January 8th.
Yes, Judge.
And I'm assuming it's going to be a plea at a time.
That is correct, Judge.
Okay, very well. All right, we'll set Ms. Gregson in for January 8th. Plea at 1:30.
Thank you, Judge. Judge, next ready on Miranda Hatton.
Miranda Ann Hatton, CR 25-146. Ms. Hatton is set for docket call.
Yes, Judge. We have a tentative agreement. However, Ms. Hatton is not in a, well, I don't have the paperwork yet, but in discussing some of the conditions of probation and some of the questions she had, I don't believe she is currently competent and ready to go forward with the plea, and so we request additional setting on her case.
You want to set it for plea or you?
Judge, if we can just do a final docket call.
All right, court sets Ms. Hatton for final docket call January 8th at 1:30.
And Judge, my understanding is that my last client, Mr. Hagel, he is in a holding cell and is not allowed to be brought with people who are currently in the courtroom. We are going to be, the plan had been to plead his case today. However, after speaking to him in the holding cell, he is requested an additional setting. And so we'd be setting that, I believe, setting that one for docket call as well. And I can just get his reset signed if the court would allow that.
Okay, any objections from the state?
Your Honor, no objection to resetting it. I believe it'll be January 22nd. But just if Mr. Hagel intends on pleading true, just if we can have enough heads up to make sure that all the paperwork and dates are ready, which I'm sure Mr. Manning will. But or if we need to contest it, we have some witnesses that we need to get a hold of.
All right, so what we're gonna do, we're gonna set it for January 8th for the status of plea. And then we're gonna go ahead today and set it for the 22nd. If no plea is reached on the 8th, then we'll set it for contested on the 22nd, and everyone will be on notice to be ready.
Thank you, Judge.
Thank you.
Judge, I believe that concludes my business. May I be excused?
Yes, thank you, Mr. Manning.
Thank you, Judge.
All right, court will stand in recess until more, I guess Mr. Schmidt's the only one left. Give Mr. Schmidt some time to talk to his clients, and then Mr. Abraham will let us know when they're.
Your Honor,
Yep.
I believe our interpreters, online,
Yes, I believe she is, but I didn't see anybody ready.
we are.
Yep.
Nadia, right there?
Yeah.
Okay.
So there's. Yeah, that's it. Oh. You basically like two.
Yeah, that's all it is. Okay,
Miss Bill, were you able to make contact with Mr. Martinez?
One round.
Yes, sir.
Que lo oiga. Okay.
All right, Miss Bill, if you'll raise your right hand, state your name and your license number for the record. Miss Bill, do you solemnly swear or affirm that you will make a true translation of the statements of the court, questions of counsel, and the testimony to be given by the witness in the matter now on trial to the best of your skill and judgment, so help you God? Bless you. All right, you can lower your hand. This is cause numbers CR 25-166, 167, and 168. State of Texas versus Orban, Ariel, Martinez, Arazo, Mr. Schmidt. I believe they were set for plea today. Is that correct?
That's correct.
And are we pleading today?
Yes, sir. You should have the paperwork in your queue.
All right, let me go. All right, Mr. Martinez, if you will raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I believe.
See,
All right, thank you. You can lower your hand. All right, Mr. Martinez, are you a United States citizen?
no,
Do you understand that entering a plea of guilty in this case today could have an adverse effect on your status in the country or your re-entry into this country?
No sé.
Have you discussed your legal status in this country with your attorney, Mr. Schmidt, regarding this case?
sí,
And Mr. Schmidt, do you believe that Mr. Martinez has been adequately advised regarding the nature of his plea and how it might affect his status in the country?
Yes, sir. He has a pending immigration hold. Once this case is done, he's been informed that when he's released from Van Zandt County custody, that he'll be taken into ICE custody for deportation proceedings.
Very well. Mr. Martinez, have you ever had any type of mental health diagnosis? Have you ever been
No.
treated for mental health? All right, in this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt in the work that he's done as your attorney?
Sí.
Do you understand everything that you've read and signed today in your plea agreement?
Hable. Sí.
Mr. Schmidt, do you believe your client to be competent to enter into a plea agreement? And if so, do you believe that he's doing it intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Yes, I do.
All right, Mr. Martinez, in cause number CR 25167, I see that you are charged by indictment with an offense of abandoning or endangering a child, a state jail felony, which does carry a range of punishment not less than 6 months or more than 2 years confinement in prison. I see today that the plea agreement is for you to plead guilty to that offense. In exchange, the state is making a recommendation that you be punished under section 1244A of the Texas Penal Code, meaning that you would be convicted as a felon, but you would be punished as a misdemeanor offender. And their recommendation is that you serve 234 days confinement in the county jail, for which you would receive credit for 234 days of time already served. You would be assessed a fine of $750, court cost of $290, and reimbursement fees of $520. Also, a part of the agreement and recommendation, the state is going to ask the court to dismiss your other 2 indicted causes, which are CR 25166, which is evading arrest or detention in a vehicle, and also CR 25-168, which is prohibited substance or item in a correctional facility. Mr. Martinez, is that your understanding of the plea agreement and what you're asking the court to approve?
Sí.
All right, Mr. Martinez, with the court having explained to you the range of punishment in the plea agreement, at this time, I would ask you, how do you plead to abandoning or endangering a child, a state jail felony?
Creo que no soy culpable.
You're not guilty? Okay. Mr. Schmidt, is that what you anticipated was going to
No.
happen during the plea agreement?
No, sir.
Okay, so Mr. Martinez, the court cannot accept a plea agreement wherein you say that you are not guilty of these offenses. Therefore, the court will have to reject your plea agreement and we will have to set you for trial. Is that what you want to do today?
Si soy culpable de lo que hice,
The question is, are you guilty of the criminal offense that you've been charged with, which is abandoning or endangering a child? Are you guilty of committing that
sí.
offense?
Sí.
Mr. Martinez, what did you mean when you said that you were not guilty? What were you referring to?
O porque no he entendido bien lo que me está. ¿Sí me escucha?
So you're telling me at this time, Mr. Martinez, that you are in fact guilty of committing that offense of abandoning or endangering a child?
Sí, sí,
And Mr. Martinez, has anyone pressured you, threatened you, or forced you to plead guilty to that crime?
no,
The court will then accept your plea of guilty to that offense at this time. Mr. Schmidt, any objection to the admission of the evidence?
No objection.
The evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Is there anything further from the state?
Nothing further, Your Honor. Thank you.
Is the state in compliance with any kind of victim notification on the endangering charge?
Yes, Your Honor. State did not receive any contact communication back from the child in the case.
Is there another parent or another guardian or anyone else that has any kind of?
Your Honor, there is another parent that picked the child up the night of the offense, but we didn't receive any communication back.
But you did send it out to that other parent.
Correct, Your Honor.
Anything further from the defense?
No, sir.
All right, then the court will review the evidence at this time. All right, and Mr. Hartwell, I see that based on the stipulation that Mr. Martinez was evading police officers at a high rate of speed that resulted in a crash. And during that pursuit, the endangering a child conduct was that he had a 14-year-old child in the car. Was the child at all injured in the crash?
Your Honor, nothing that required any hospital stays. At the time, law enforcement brought the child to the Van Zandt County Sheriff's Office where her mother picked her up, so she didn't require any hospitalization.
All right, very well. All right, anything else from the state?
No, sir. Thank you.
Anything else from the defense?
No, sir.
All right, then based on the court's review of the evidence, the court finds that the evidence does substantiate the defendant's guilt. Court will follow the plea agreement today and recommendation. The court hereby convicts the defendant, Orban Ariel Martinez Arazo, of endangering a child, a state jail felony. The court assesses punishment under section 1244A of the Texas Penal Code at 234 days confinement in the county jail. Court awards the defendant 234 days credit for the time that he has spent in jail on this cause. Further, the court orders the defendant to pay a $750 fine, $290 in court costs, and $520 in reimbursement fees. The court dismisses cause numbers CR 25-166, which is evading arrest or detention with a vehicle, and cause number CR 25-168, prohibited substance in a correctional facility. Mr. Martinez, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the court. I'm gonna have you step over to be fingerprinted with the deputy. And Mr. Martinez, do you have any questions before we conclude your case?
no.
All right, thank you, sir. Step over to be fingerprinted.
Okay, gracias.
All right, thank you, Ms. Bill. I think that completes our need your services today. Yes, ma'am. Hope you have a Merry Christmas and we'll see you very soon. Mr. Schmidt, if you want to bring your next client while I'm signing these plea papers.
Sure. Jacob.
Yeah, I've already spoken. I think 37. Oh, yeah. 37.
I'm getting some right now.
All right, is this Jacob Stanford?
It is.
All right, this is cause number CR 23-2, State of Texas versus Jacob Dean Stanford. And is this another play today, Mr. Smith?
It is, Judge. It's a withdraw and continue with amendments to safety.
All right. Was it prepared today or was it prepared a while back? Do you know?
Well, I believe it was prepared today. I don't know. I guess you wouldn't have, Ms. Abraham doesn't think you'd have a copy. I've got the state's motion and the amendments in my hand.
All right, so you said it's a withdraw, continue,
That's correct.
amend to safe B.
That's right, with the additional $500 attorney's fees and all the standard conditions associated with safety.
All right, Mr. Stanford, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Stanford, it's my understanding that there's a motion to adjudicate filed in your case. However, Mr. Schmidt, your attorney's indicated that the agreement in the case is that the state would withdraw their motion to adjudicate your guilt upon your agreement to continue on community supervision with an amendment to your conditions, wherein you would be required to go to the substance abuse felony punishment facility known as SAFE-B, which is the drug rehabilitation treatment center run by the Texas Department of Criminal Justice. If the court approves that, then you would also be responsible for an amendment of your fees that you owe in this case for an additional $500 based on the state's motion that had to be filed to get us here today. Mr. Stanford, is that your agreement and what you're asking the court to approve?
Yes, sir.
Has anyone threatened, forced, or pressured you to make that agreement?
No, sir.
In this case, you're represented by your attorney, Mr. Schmidt. I believe that Mr. Schmidt was appointed to represent you. Are you pleased with the work that he's done as your attorney?
Yes, sir.
All right, and Mr. Schmidt, you believe that Mr. Stanford's entering into this agreement intentionally, knowingly, and voluntarily after having been deemed competent by you?
Correct. Yes.
All right, then the court will grant the state's motion to withdraw. The court hereby amends the conditions of community supervision, orders Mr. Stanford to attend the SAFE-P program, and amends his conditions for an additional $500 in attorney fees. All right, Mr. Stanford, tell me what is it that you hope to accomplish at SAFE-P?
Quit smoking weed.
Sir,
Quit smoking weed.
smoking weed, anything else?
Do better. Do a hell of a lot better at it.
You understand that they're going to offer you tools and resources down there, but ultimately it's going to be up to you whether or not you accept them. No one can make you change. You understand that? Only you can change yourself.
Yes, sir.
Okay, so it's not about luck. sometimes I tell people good luck when they go to prison because I don't know what's going to happen to them in prison. Understand? But someone like you that's going to treatment, it's not about luck. It's about commitment, discipline, hard work. Understand that?
Yes, sir.
So luck is not going to help you get off weed or control your desires. Luck's not going to do that. You understand that?
Yes, sir.
All right. So don't waste a bed. Don't waste your opportunity to go down there and come back better. Okay. If you do, then you're just going to end up going to prison for weed. That'd be the dumbest thing in the world.
Yes, sir.
All right. Step over, sign your paperwork, and
You already saw it. Let's see.
who's next, Mr. Smith?
Isaac Jenkins.
Mr. Jenkins. This is cause numbers CR 24-183, CR 5-126, State versus Isaac Anthony Jenkins. And we have a docket call and a motion to revoke. Go ahead.
Judge, we'd asked to set both of those cases for plea next month.
Right, we can set that. The earliest we could set it here, a Tuesday would be January 6th.
It doesn't have to be that early, Judge. It can be on the 20th
Is he,
or whatever that.
is he taking a plea at a time?
Yes, sir.
Can we do it on the 6th so that we can?
Yes, sir, we can.
All right, let's set it on the 6th. So if he's gonna go, we'll go ahead and try to free up some space in our jail.
Yes, sir.
All right, court will set Mr. Jenkins then for plea January 6th. 1:30.
Good morning.
Would you like next?
We have Valencia in here?
Yeah.
Come on up. Come on up. Oh. Ezekiel Valencia.
Court calls number CR 24-81, CR 24-82, State versus Ezekiel Alejandro Valencia. Motions to revoke. Go ahead.
Judge, apparently I've just been appointed to represent Mr. Ezekiel Valencia today. We haven't met yet, and so we'd ask for a reset on his case and have his opportunity to go through it.
All right, court will set Mr. Valencia then to the next contested docket, January 22nd at 1:30.
Listen, you're not ready to be taken back, so don't go back. Remember, one people, I'll talk to you about this in a minute, okay? So just sit tight. Yeah.
Like next.
You should have a plea in your queue for, let's see here.
Say Valencia Fulton.
Yeah, that one's ready.
Okay. Mr. Valencia Fulton.
Yeah.
All right, give me just one moment as your plea comes up. All right, this is cause number CR 23-20, State versus Isaiah Ernesto Valencia Fulton. Mr. Valencia, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
Thanks, sir. You can lower your hand. All right, Mr. Valencia, you were before the court previously, it looks like on May 9th of 2023. On that date, you appeared before the court. You pled guilty to aggravated assault with a deadly weapon, a second-degree felony. The court heard the evidence, found that there was enough evidence to convict you. However, the court followed a plea agreement recommendation from the state, and the court deferred a finding of guilt and placed you on deferred community supervision for a period of 5 years. Court also assessed a fine of $2,500. It was during your period of community supervision that the state filed a motion to adjudicate and revoke. And in that motion, they alleged 10 separate counts or allegations of violations. Have you had enough time to read over those allegations of violations with your attorney, Mr. Schmidt?
Yes, Judge.
Did you read, did you understand everything that you read and signed in your plea agreement today?
Sir.
And I see that your plea agreement is that you're going to be pleading true, and the state is going to be recommending that upon your plea of true, that you be convicted of the offense, that your community supervision be revoked, and that your punishment be assessed at 5 years confinement in prison, and you would be ordered to pay the balance of your financial assessments, which is your fine and court costs and reimbursement fees, anything that you have left owing on those. And you're going to receive credit for the time that you spent in jail towards this cause. Mr. Schmidt, what is that credit time?
388 days, Judge.
388. So
That's
Mr.
correct.
So Mr. Valencia, you would receive 388 days credit towards that sentence. Is that your understanding of the plea agreement, what you're asking the court to approve?
Yes, sir.
Mr. Schmidt, do you believe Mr. Valencia to be competent today? And if so, that he's entering into this agreement intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Yes, sir.
All right. And does your client intend to waive the formal reading of the state's motion and enter a plea of true to all counts?
That's correct, Judge.
All right, Mr. Valencia, then I'm going to ask you at this time, how do you plead to counts 1 through 10 contained in the motion? Are those counts true or not true?
True.
You're telling me that those counts are true because in fact they are true. You're not just saying that to get a plea agreement. Is that correct?
Correct.
And Mr. Valencia, has anyone threatened, forced, or pressured you to plead true to any counts here today?
No, sir.
All right, the court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the evidence being admitted?
No objection.
Court hereby admits into evidence the defendant's waiver of rights and plea of true to state's motion to adjudicate. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then, based on the court's review of the evidence, the court hereby finds that the defendant has violated the terms and conditions of his community supervision. The court finds all 10 counts alleged in the state's motion to be true. Based on that finding, the court follows the plea agreement. The court hereby adjudicates the guilt and convicts Isaiah Ernesto Valencia Fulton of aggravated assault with a deadly weapon. Court finds that the deadly weapon was used, but it was not a firearm. The court hereby revokes his community supervision, assesses his punishment at 5 years confinement in the Texas Department of Criminal Justice, and orders him to pay the balance of his financial obligations. The court hereby awards Mr. Valencia 388 days credit towards his sentence for the time that he's been in jail on this cause. Mr. Valencia, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. Mr. Valencia, once you get out of prison, if you've not paid off your fines, court costs, and those other fees, those are still going to be outstanding. So you're going to report to the courthouse, make a payment arrangement, and we'll try to get those things paid off so that you don't get another warrant and get rearrested. Okay.
Yes, sir.
All right. Please step over to be fingerprinted.
Is Furlough in here?
No.
Okay. Huh? You done did me.
I did?
You did. That's okay. I'll say something next time.
Next, Mr. Schmidt.
Carnes, you should have Carnes in your queue for plea. On down, baby.
Court calls cause number CR 24-275 and CR 24-276, State versus Benjamin Colin Carnes. Mr. Carnes, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you, sir. You can lower your hand. Your name is Benjamin Colin Carnes, is that correct?
Yes, Your Honor.
And Mr. Carnes, are you a United States citizen who reads, writes, and speaks English?
Yes, Your Honor.
Have you ever been diagnosed with a mental condition?
Yes, Your Honor, I have
Can you tell me what that is?
depression. That's about it.
Are you on medication or under treatment for depression?
Yeah, I'll take medication every day.
All right. Do you feel like you are in a good mindset today and that your depression is, or your medication is in no way affecting your ability to understand what's going on in court?
Yeah, 100%. I'm good.
Good. All right. And in this case, Mr. Carnes, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt and the work that he's done as your attorney?
Yes, Your Honor.
You understand everything that you've read and signed that's in your plea agreement?
Yes.
Do you have any questions about anything before we proceed?
No, sir.
All right, Mr. Schmidt, do you believe Mr. Carnes to be competent to enter into a plea agreement? And if so, that he's doing it intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Yes.
And what kind of credit time is Mr. Carnes entitled to on his sentence today?
94 days.
Say 9-4?
9-4.
9-4, thank you. All right, so Mr. Carnes, I see that you are charged by indictment in CR 24-276. You were charged with aggravated assault with a deadly weapon, a second-degree felony. However, it looks like the plea agreement today is to a lesser included offense of a third-degree felony, injury to a child, elderly, or disabled individual, with that range of punishment being not less than 2 years in prison or more than 10 years in prison and a possible fine not to exceed $10,000. The plea agreement appears to be, upon your pleading guilty, the state's recommending that the court assess your punishment at 5 years confinement in prison, a $1,000 fine. As part of the plea agreement, the state is agreeing to dismiss the other aggravated assault with a deadly weapon charge. In addition, you would be ordered to pay a $1,000 fine, $290 in court cost, and $120 in reimbursement fees, and you would receive 94 days credit toward your sentence for the time that you've already spent in jail. Mr. Carnes, is that your understanding of the plea agreement?
Yes, Your Honor.
All right, then at this time, I would ask you, how do you plead to the lesser included offense of injury to a child, elderly, or disabled individual?
Plead guilty.
Are you pleading guilty to that crime because you are guilty of committing that crime?
Yes, Your Honor.
Mr. Carnes, has anyone threatened, forced, or pressured you to plead guilty?
No.
The court will accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No objection.
All right, the evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that the state is in compliance with victim services. Victim impact statements were sent out and not returned.
All right, thank you, sir. All right, the court's going to review the evidence. Anything further from the defense, Mr. Schmidt?
No, sir.
Court's going to review the evidence. All right, the court, having considered the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement today. The court convicts the defendant of the third-degree felony offense of injury to a child, bodily injury. Assesses punishment at 5 years confinement in the Texas Department of Criminal Justice. Assesses a $1,000 fine, $290 in court cost, and $120 in reimbursement fees. The court hereby dismisses under section 1245. Actually, no, I don't believe it's 1245. The court just dismisses based on the state's motion as part of this agreement. Cause number CR 24-275, aggravated assault with a deadly weapon. And the court awards the defendant 94 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Carnes, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. Once you're released from prison, if you've not paid off the money that you owe, you need to report to the courthouse and make a payment plan. Do you understand?
Yes, Your Honor.
All right, please step over with the deputy to be fingerprinted.
Yes, sir. I think yes, but we.
Mr. Schmidt, next.
This is Seth Atkins.
Right, this is cause number CR 22-368, State of Texas versus Seth Edward Atkins. State's motion to revoke. Are we here today on the status, I think?
We are on status. We're on status, Judge. As far as I know, I think there are 3 new felony offenses. I don't think the state, I don't know if they intend to push those to the grand jury or not. As far as I know, they haven't been at this point. So on the motion to adjudicate, we will ask for a reset on that.
Are we still awaiting an evaluation?
I don't think that it's been ordered, Judge, but if it hasn't been, we're gonna request that.
Well, correct me if I'm wrong, I thought you had followed a motion or suggested that at the last hearing that we had.
I did. I recall doing that, but I don't think that that's occurred.
Ms. Abraham, do you know?
You haven't been evaluated. He hasn't been evaluated, Judge. I know he hasn't, and I'm not sure. And
No, I'm just
I
talking
think
about
that,
have we ordered it? Have we ordered it as the process started?
yeah, I haven't seen that order, no.
All right, stand by for just a.
Spicy green on much. Yeah, well, I looked at frozen burrito from, oh, yeah. It's fighting back. Medication. But, dangerous. See, actually, got it over there. I don't know where they found it.
All right, Mr. Schmidt. All right, so I reviewed the case and yeah, I don't think, but I would ask that you just file a motion so that I can have that of record.
Yeah, sir, I certainly will. I'll do that this week.
All right, so you're saying that there are new cases, and I guess these are alleged to occur previous to him being taken into custody by the court back in November.
That's correct. Well, no, because I believe that he was taken into custody based on new offenses. And then he was on bond on this motion. And I think we asked the court to go off his bonds on that one. And so we haven't gotten any information on new offenses yet. I don't think they're alleged in the state's motion, but I presume they would be.
Mr. Harwell, can you shed some light on this for us?
Your Honor, I'm not sure if we filed an amended motion yet. If not, I expect we will be. However, as far as waiting on these other offenses, looks like we received some more information recently here, some supplemental reports. So we're going to review that, make sure that the entire case is present for review and presentation to the grand jury. If it is in fact the entire case, I expect that would be presented here pretty quick.
All right, court will reset, Mr. Atkins to January 22nd for a status on mental health and new case.
Yeah. Real quick.
I'll get that. Yeah, man, you did. Yeah.
Who's next?
I think that's all we have ready right now. I've got some more papers in my queue that I need to go through. We'll
Okay.
get those done as quick as we can.
All right, court will stand in recess. Just let us know when you're ready.
Yes, sir.
Your Honor, excuse me, Your Honor.
Patty, are y'all ready? I'll let him know.
All right, Mr. Schmidt, who do you have?
This is Jordan Holloway.
All right, court calls CR 25-204, CR 25-225, State of Texas versus Jordan Lee Holloway. And is Mr. Holloway going to be entering a plea today?
Mr. Holloway will be entering a plea on CR 25-00204 on 225. We're going to ask the court to reset that for a plea. There are some issues with some of the factual or legal sufficiency that I need to sit down with Mr. Hartwell before we wrap that one up. Judge, after Mr. Holloway pleads to the 204 case, we're going to request that the court grant him a personal recognizance bond on the remaining cause, as that's going to be a probation plea. But we just got to sort some stuff out, but we're prepared to proceed on 204.
All right, Mr. Holloway, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your name is Jordan Lee Holloway, is that correct?
Yes, sir.
Mr. Holloway, are you a United States citizen who reads, writes, and speaks English?
Yes.
You ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Yes,
Do you understand everything that you've read and signed as part of your plea agreement?
yes,
Do you have any questions before we go further?
no, sir.
All right, Mr. Schmidt, do you believe Mr. Holloway is confident today that he's entering into this agreement intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Yes, sir.
All right, Mr. Holloway, in cause number CR 25-204, you are charged by indictment with a third-degree felony offense of continuous violence against the family, which carries a range of punishment of not less than 2 years or more than 10 years confinement in prison and a fine up to $10,000. I see that the plea agreement and recommendation from the DA's office is that you would plead to a lesser included offense of assault causes bodily injury of a family member, a class A misdemeanor. They're recommending that punishment be assessed at 147 days in the county jail, for which you would have 147 days credit towards that sentence for time already served. You'd also be assessed a $100 fine, $270 in court costs, and $20 in reimbursement fees. Mr. Holloway, is that your understanding of the plea agreement, which you're asking the court to approve?
Yes, Your Honor.
All right, Mr. Holloway, at this time, how do you plead to assault causes bodily injury of a family member, a class A misdemeanor?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty to that crime?
No.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the evidence being admitted?
No objection.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Further from the state.
Your Honor, just that the state is in compliance with victim services. Victim impact statement was sent out, was not returned.
Very well. Mr. Schmidt, anything further from the defense?
Not pertaining to this, cause number, Judge.
All right, the court will review the evidence. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of this offense. The court will follow the plea agreement and the recommendation. DA's office, the court hereby convicts the defendant, Jordan Lee Holloway, of assault causes bodily injury of a family member, Class A misdemeanor, finds that family violence was involved, and the court makes an affirmative finding. The court assesses punishment at 147 days confinement in the county jail. The court awards Mr. Holloway 147 days credit towards his sentence for the time served, and the court orders the defendant to pay a $100 fine, $270 in court costs, and $20 in reimbursement fees. All right, on this cause, Mr. Holloway, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of this sentence. Once we're through making the announcement on your other case, then you're ordered to step over to be fingerprinted. All right, what's the announcement on cause number CR 25-225?
Judge, the announcement is that we were set to plea. I was reviewing the stipulation and some of the other evidence in Mr. Holloway's file in that case. I think that he was prepared to plead to a conviction with probation, 5 years. And at this point, my contention with Mr. Hartwell is that it's factually insufficient to substantiate a plea of guilty, and the court, I don't think, can accept it as is. So what we are asking is that be reset to plea, and that me and Mr. Hartwell will sit down with the discovery again together to make sure that there is factual sufficiency to meet or substantiate a plea of guilty on attempted arson. Right now, my argument is I don't believe that it is. Mr. Hartwell's argument that he believes it is, but I can't let him go forward with a plea on that. But because the state was prepared to plead to probation, I spoke with Mr. Hartwell, and he's in agreement. Make an oral motion for the court to grant Mr. Holloway a personal bond on this cause. obviously with the standard conditions, including no contact with the alleged victim. And while we're waiting to wrap up the case, hopefully next month.
And so Mr. Holloway is, show Mr. Holloway to be on bond in that case, CR 25-225. He's on bond with Roy Brockway bail bond for $1,500, I believe.
I don't know how that's possible, but if that is the case. Are you on Clay Nichols?
The bond,
I was out on bond, they arrested me. Last time.
share my screen. This is what's coming up in that cause number with the clerk. Now, the bond does says terroristic threat. It does say terroristic threat causes fear of imminent serious bodily injury.
And I think that charge
And-
has changed.
That's correct, Your Honor.
Well, I can't hear you. What was correct?
The charge was changed from terroristic threat to attempt. The docket has arson. It was changed to attempted arson, and indicted as attempted.
I mean, it still remains the fact that he's on bond for it, right?
That makes sense to me, Your Honor. I'm unaware of Roy Brockway filing a surrender of principal or anything like that.
Yeah, there's no surrender, so he's showing to be on bond
And-
since unless this is wrong.
What I'm looking at, Judge, on the Van Zandt County Jail bookend sheet is he's been booked in, he's being held on $100,000 on the one we just pled. And 25,000 on evading arrest detention, which I'm unaware of, but the date of offense is the same.
This is what is the clerks have filed into the case, which doesn't mean it's accurate. It just means it's filed into that case.
Okay.
I see that this was in April of 2025, and the indictment in this case.
And that makes sense based on what I'm looking at, Judge. I would ask though, since this would be the last docket of the year, that in the event Mr. Holloway is still being held on this charge, I don't think there'd be another one, that the court would allow us to submit an agreed order on personal bond to clear that up. In other words, I mean, normally you would set that for a hearing, and we will not have an opportunity prior to the holidays to do that. So I'm just concerned that it won't match up whenever we.
Yeah, I understand. It looks like it's going to though, because here's the offense date of April 18th. So, yes, you can submit it and the court will review it, without a hearing.
Okay, thank you, Judge. And we need a setting for the plea.
All right, court will set, do you want to set this January 6th?
Yes, sir.
All right, court sets CR 25-225, plea January 6th at 1:30.
You can try. You understand it. So one, so with that, to take care of the. And I'm just making sure that. Set it down. Sure that it's, or that. Get out, until we come back. When we come back on the 6th, if you're out, which you should be, then you need to be at the courthouse at 9 a.m. You're not over here, okay? I'll get your thumbprint on that, Judge. All right, go over there and get that done.
No, you want both charges.
I saw it too.
I mean,
Right. There's another one, so we'll have to submit additional paperwork in that. What? Uh-huh. Yeah. You should have, Moody. Mr. Moody, come on down.
My court calls cause number CR 14-237, State of Texas versus Randall Clay Moody. Mr. Moody, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can vote. All right, Mr. Moody, you've been on probation in this court. You appeared on December 7th of 2017. You pled guilty to driving while intoxicated, third or more offense, a third-degree felony. On that day, the court heard the evidence and your plea bargain. The court assessed your punishment at 10 years confinement in the Texas Department of Criminal Justice. The court then followed a plea agreement and suspended the sentence and placed you on community supervision for a period of 8 years. And then you were ordered to abide by the terms of community supervision, and it was during your period of community supervision that the state filed its motion to revoke on May 15th, 2025. And the state has alleged 2 allegations of violations. Have you had enough time to review that motion with your attorney, Mr. Schmidt?
Yes, sir.
Are you pleased with Mr. Schmidt as your attorney?
Yes, I am.
Do you understand the terms of your plea agreement?
Yes, sir.
Do you have any questions about anything before we go?
I just wanted to get the run concurrent, didn't you?
Yes, that's correct.
I don't have any questions.
Mr. Schmidt, do you believe Mr. Moody to be competent to enter into the agreement? And if so, that he is doing so intentionally, knowingly, and voluntarily after having been fully informed of his legal rights?
Yes, sir.
All right, Mr. Moody, I see upon your plea of true to those allegations in the state's motion, the state is recommending to the court that the court consider the evidence, the court revoke your community supervision and assess your punishment at 3 years confinement in prison, along with balance of your financial obligations, which is fines, court costs, and reimbursement fees as laid out in the judgment. Is that your, and Mr. Schmidt, how many days credit time will he be entitled to?
439.
439. And so you would be entitled to 439 days credit towards your sentence. Is that what your understanding of the plea agreement is, Mr. Moody?
Yes, sir.
All right, understanding all of those things, Mr. Schmidt, does your client waive the formal reading of the state's motion? Does he?
Yes, sir. We waive.
He's going to plead true to both counts.
Yes, sir.
All right, Mr. Moody, then at this time, I would ask you, how do you plead to counts 1 and 2 contained in the state's motion? Are those counts true or not true?
True.
You're pleading true because in fact, the allegations against you are true, correct?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead true?
No, sir.
Court will accept the defendant's plea of true to each count as alleged. Mr. Schmidt, any objection to the admission of the defendant's waiver of rights and plea of true in evidence?
No objection.
That is admitted, and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Nothing further, Your Honor. Thank you.
Anything further from the defense?
No, sir.
All right, then based on the evidence before the court finds that the defendant, Randall Clay Moody, has violated the terms and conditions of his community supervision. The court will follow the plea agreement today. The court hereby revokes community supervision of the defendant, sentences him to 3 years confinement in the Texas Department of Criminal Justice Institutional Division, orders him to pay the balance of his financial obligations. The court awards time credit of 439 days towards that sentence for time already spent in jail on this cause. Mr. Moody, once you get out of TDC, if you've not paid off your fines, court costs, and fees, then you're ordered to report to the Van Zandt County Courthouse. Otherwise, failure to pay could result in a warrant being issued for your arrest. Do you understand?
All right.
All right, Mr. Moody, you're hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. All right, Mr. Schmidt, who do you have?
This is Mark Adam Shirkey.
Mr. Shirkey will be entering a plea today.
That's correct.
All right, court calls cause numbers CR 25-158 and 159, State versus Mark Adam Shirkey. Mr. Shirkey, if you'll raise your right hand, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you,
Yes.
sir. Over to you. All right, Mr. Shirkey, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
Yes, sir.
Can you tell me what that is?
Bipolar?
Are you currently on medication and undergoing treatment for that?
No, sir.
Do you feel like you have a rational understanding of what's going on in court today?
Yes, sir. Yes, sir.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with him as your attorney and the work that he's done?
Yes, sir.
Do you understand everything that you've read and signed that's in your plea agreement?
Yes, sir.
Do you have any questions about anything?
No.
Mr. Schmidt, do you believe Mr. Shirkey to be competent? And if so, that he's entering into this plea agreement intentionally, knowingly, voluntarily, after having been informed of his legal rights?
I do.
All right, Mr. Shirkey, I see in cause number CR 25-159, you are charged with the third-degree felony offense of evading arrest or detention with a vehicle. That does have a range of punishment of not less than 2 years or more than 10 years in prison, and a fine not to exceed $10,000. I see the plea agreement in your case. Upon you pleading guilty, the state's recommending that the court accept that plea, find you guilty, and assess punishment at 3 years confinement in prison, along with restitution in the amount of $11.34, court costs of $290, and reimbursement fees of $55. In addition, the state would, as part of the plea agreement, be asking the court to dismiss the burglary of a building charge that you're indicted for in cause number CR 25-158. Mr. Shirkey, is that your understanding of the plea agreement?
Yes, sir.
Mr. Schmidt, what's the credit time Mr. Shirkey's entitled to?
We have 243 days.
243. So Mr. Shirkey, you would also receive 243 days credit time towards that sentence for time you've already been in jail. You understand that as well?
Yes, sir.
All right, understanding all of those things, Mr. Shirkey, I ask you at this time, how do you plead to evading arrest or detention with a vehicle?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No.
All right, the court does accept the defendant's plea of guilt. Mr. Schmidt, any objection to the evidence?
No objection, no.
The evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that in cause number CR 25-158, that burglary of a building. As part of this agreement, we were looking into whether there was any restitution. There was no restitution request returned to the state. Additionally, the alleged victim in that case said that all the property had been returned to him.
Thank you, Mr. Harwell. Anything further from the defense?
No, sir.
All right, court's going to review the evidence at this time. All right, the court, having reviewed the evidence, finds enough evidence to convict the defendant of the offense. The court follows the plea agreement. The court convicts the defendant of evading arrest or detention with a vehicle. Assesses punishment at 3 years confinement in the Texas Department of Criminal Justice. Orders restitution in the amount of $11.34, court costs in the amount of $290, and reimbursement fees in the amount of $55. The court awards the defendant 243 days time credit towards his sentence for time spent in jail on this cause. Mr. Shirkey, once you get out of prison, if you've not paid off your court costs, reimbursement fees, restitution, then you need in order to report to the Van Zandt County Courthouse so that you can enter into a payment plan to take care of those. Otherwise, the court could issue a warrant for failure to comply with court. Do you understand that?
Yes, sir.
All right. Mr. Shirkey, hereby remanded to the custody of the sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
All right.
Thanks, Mr. Smith. Who's next?
Oh, this is Mr. Cromwell.
All right. This is cause number CR 24-309, State of Texas versus Philip Shane Cromwell. I believe that Mr. Cromwell is currently on the court's special trial settings for trial. And so we're set for status today. What's the announcement?
Judge, we received an offer from the state. Mr. Cromwell wishes to accept it. We've entered into the plea. Paperwork should be in your queue, and we're prepared to proceed.
All right, what's the terms of the plea agreement?
Judge, Mr. Cromwell will be pleading to a lesser criminally negligent homicide. Essentially time served. I believe that's in the plea block of the judgment. I don't remember the number of days. And a $1,500 fine.
Hey, Sergeant. That guy got put in cell too? Did you tell him he passed the limit? Yeah.
This paper is done today or another day, Mr. Smith?
Yes, sir. I said we submitted them about 30 minutes ago.
Check the date on there, cause me and, Rodriguez will
You
got
have to
cell.
search the defendant's last name and they will appear. I don't have that. I don't have that in my queue. Or my email. It's not a queue. I'll have it in my email. Have a revised March.
Okay, Judge, I see the problem. No, I don't see the problem. Let me double check to make sure. I know we reviewed and submitted one set. Yeah, it says it's already been signed by me. Let me check the other set real quick. And it's entitled CRETDCJ
And it, okay,
instead.
it's from Mr. Harwell. Do have-
Yeah, that's correct. Yeah, that's it.
All right, this is cause number CR 24-309, State of Texas versus Philip Shane Cromwell. Mr. Cromwell, if you'll raise your right hand, I'm going to place you on your oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, nothing but the truth, so help you God?
Yes, sir.
All right, lower your hand. Your name is Philip Shane Cromwell, is that correct?
That's correct.
All right, Mr. Cromwell, you've been indicted for a first-degree felony offense of murder, which carries
And
a
Your Honor, pardon me, I don't know if Your Honor is going to proceed on the superseding indictment because there was a superseding indictment.
I'm just going to go through the procedural history of everything.
Thank you very much. I appreciate that. Okay, my apologies.
It's okay. You were originally indicted with the offense of murder, which is a first-degree felony, carries a range of punishment, not less than 5 years or more than 99 years or life confinement in the Texas Department of Criminal Justice. I believe that indictment was then superseded by a re-indictment of the offense as a second-degree felony offense of manslaughter, which is carries a range of punishment not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice and a fine not to exceed $10,000. However, I see that today there appears to be a plea agreement recommendation from the DA's office wherein you would plead guilty to a lesser included offense of criminally negligent homicide. That is a state jail felony and has a range of punishment of not less than 6 months or more than 2 years confinement in the Texas Department of Criminal Justice. I see that the plea agreement is that you would plead guilty to that crime in exchange for their recommendation of sentence being assessed at 404 days confinement in the Texas Department of Criminal Justice, with you receiving, Mr. Schmidt, I believe you said 404 days. Is that correct?
That's correct, Judge.
You receiving 404 days credit towards that sentence. In addition, you would be ordered to pay fines of $1,500, restitution in the amount of $3,703.14, court cost of $290, and reimbursement fees of $20. Mr. Cromwell, are you a United States citizen who reads, writes, and speaks English?
Yes, sir, I am.
Have you ever been diagnosed with a mental condition?
No.
In this case, you're represented by your attorney, Mr. Richard Schmidt. Are you pleased with Mr. Schmidt as your attorney?
Very pleased.
Do you have any questions about anything?
No, sir.
Mr. Schmidt, do you believe Mr. Cromwell to be competent to enter into this plea agreement?
Yes, sir.
And do you believe that he's entering into this intentionally, knowingly, and voluntarily after having been informed of his legal rights?
That, in addition to that, Judge, Mr. Cromwell is specially set for trial in February. And I did reiterate that setting was still available if he wished to pursue a jury trial. And after, explained to him his rights, I believe he's knowingly and voluntarily proceeding with the plea.
All right, so Mr. Cromwell, I've advised you of the range of punishment and the terms of the plea agreement. At this time, how do you plead to criminal negligent homicide?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anyone threatened you, forced you, or pressured you to plead guilty?
No, sir.
All right, the court does accept the defendant's plea of guilt at this time. Mr. Schmidt, any objection to the stipulation of evidence?
No objection.
All right, the evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Mr. Hernandez, can you address the change of our procedure here from setting for trial on murder, then manslaughter, and then the plea today to criminally negligent homicide, and how it relates to the evidence and the victim stance in the case, if any?
Certainly, Your Honor. Initially, when the case was brought forth to the district attorney's office, there was in particular a witness statement who claimed he had seen certain things, which allowed this office to present a case before the grand jury and requesting.
I'm sorry, just can you repeat that? There was some interference. I couldn't hear the last little bit.
Sure. Initially, there was a witness who provided information which allowed the DA's office to pursue a first-degree murder indictment. The grand jury agreed to that and issued said indictment. As the investigation continued, that witness actually recanted their statement completely and stated that they did not, in fact, see what they had initially stated they saw. That in itself changed the tenor of the investigation, and we were no longer in a position to be able to prove the intent portion of the first degree murder charge alleged. So the information was taken into account and once again presented to the grand jury, at which time they came back with an indictment on manslaughter. All of that was presented to the family. They are in agreement. You have several statements, I believe, from family members. The state is in compliance, but it's for that reason that we finally arrived at the plea that you have before you to this afternoon.
Okay, thank you. And you said those victim impact statements have been submitted to the court?
Yes, sir.
Okay. Ms. Tabraham, do you have those or are they?
Your Honor, they were sent while we've been out here at the jail.
Okay, they were sent, okay. Are they in your email or my email?
They're in my email, Your Honor.
All right, can you forward those to me?
Yes, sir.
So what we'll have to do is take a brief recess. I need to review those before I go forward on the rest of the plea.
And Your Honor, just so you're aware, obviously those went out initially after the first indictment, so they bear that information. And I think the folks that were addressing their impact statements were speaking as to that initial indictment.
Okay, but you're telling me what I'm going to read in some of these victim impact statements is that they are they approve the agreement today to reduce to criminally negligent homicide and time served.
Well, actually, those conversations were had within the last few days with the contact person with the family. I believe it was a daughter, they were in agreement. I don't know that that's necessarily going to be the most updated victim witness, a victim statement that's provided to the court.
Okay, so I'm not sure it'll be beneficial for me to review the other ones if you don't believe they reflect the feeling of the alleged or of the victim's family to this.
Well, at least not to this plea where we are today, Your Honor.
All right, but as an officer of the court, you're telling me that the victim's family is supportive and they're asking the court to approve this very specific plea.
That's what I was informed of, and I checked that and confirmed that prior to being here this afternoon.
Very well. Okay, then okay, we'll continue. All right, anything further from the defense, Mr. Schmidt?
No, sir.
Okay, all right, the court's going to review the stipulation of evidence. All right, based on the evidence contained in the stipulation of evidence, the court finds that there is sufficient evidence to convict the defendant of the offense of criminally negligent homicide. Based on the recommendation from the DA's office with support from the victim's family, the court will follow the plea agreement. The court hereby convicts the defendant of criminally negligent homicide, assesses punishment at 404 days confinement in the Texas Department of Criminal Justice State Jail Division, awards credit in the amount of 404 days for time served. Court also assesses a fine of $1,500, restitution in the amount of $3,703.14, court costs in the amount of $290, and reimbursement fees of $20. Mr. Cromwell, when you are released from TDC or the Van Zandt County Justice Center, as it may be, you are ordered to pay your fines, restitution, court costs, and fees. If you're not able to pay those at once, then you are ordered to enter into a payment plan at the district clerk's office. Failure to do so could result in the court issuing a warrant for violation of court order. Do you understand that?
Yes, sir, I do.
All right, Mr. Cromwell, you're hereby remanded to the custody of the sheriff so we can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted.
Appreciate it.
You're welcome. Just one moment.
Thank you. Can you please see?
Abraham, what about Clayton Dean Furlow?
Your Honor, he has just filled out his affidavit and Mr. Smith is talking to him as we speak, and we are going to arraign him.
Very well. Okay, thank you. Is that all we have after Mr. Furlow? Anyone else?
I believe, no, that's all we know of.
Ready?
All right.
Mr. Furlow.
Come on down here with Mr. Furlow.
All right, court calls number CR 25-182, State of Texas versus Clayton Dean Furlow. Mr. Furlow is set for arraignment today for aggravated sexual assault, a first-degree felony, which carries a range of punishment not less than 5 years or more than 99 years or life confinement in prison and a possible fine not to exceed $10,000. The court today finds Mr. Furlow to be indigent for purposes of the Sixth Amendment. Court has appointed counsel, the Honorable Richard Schmidt. Mr. Schmidt, have you had an opportunity to go over the indictment with Mr. Furlow? And if so, are you ready for arraignment?
Yes, sir. His name is spelled correctly. Understands the range of punishment and the charges, enters a plea of not guilty, and asks for a pretrial setting.
All right, the court does enter Mr. Furlow's plea of not guilty into the record. The court will set Mr. Furlow then for pretrial hearing. Mr. Schmidt, you want February 3rd?
That's fine, sir.
All right, court sets Mr. Furlow then for pretrial February 3rd at 1:30.
This is your sign right there. Very quick. Good, very good.
Mr. Abraham, anything further?
No, Your Honor.
All right, I believe that's going to conclude our criminal docket for the calendar year of 2025. So we will resume for the criminal docket in January on January 6th. Appreciate everyone's work. Have a Merry Christmas.
Thank you, Your Honor.
Thank you, sir. Bye-bye.